and he's already joined us. He's been waiting for quite some time, but we'll crave his indulgence so that we'll listen to Lawyer Kwesi for a few minutes, and then we'll take Comrade Kwesi Pratt, who is a student of history and the director of TV Africa, not TV Africa, Pan-African Television. He's well known to all of us, and so he doesn't need much introduction. His presentation will continue to introduce him as to who he is and the important role he's playing in this beloved nation of ours. Lawyer Kwesi is a lecturer in constitutional law at the Law School, University of Professional Studies, Accra. He's also a doctoral fellow at the Widener University, Delaware Law School in the United States of America. He holds an LLM from the George Washington University Law School in the United States. We are privileged to have Lawyer Kwesi, Albert Kwesi, with us this afternoon. And so with patience and rapt attention, let's listen to Lawyer Kwesi if he's ready.
I
suggest that we all keep our microphones. Muted so that we can listen to the speaker. Any of us who generates background noise unnecessarily will be muted, or if the person persists, we'll take the person off without any offense. The thing is to allow for smooth flow of the discussion so we can have a very fruitful deliberation. Now, this program is being organized by the Progressive Intellectuals. Progressive Intellectuals comprises academics and other intellectuals across the country. A cross-section of them derive from Ghana's tertiary institutions, but we have so many progressive intellectuals outside the tertiary institutions as well, who are members. Progressive Intellectuals is a think tank, or what we ourselves refer to as an ideas factory. And we are concerned about the social democratic development of this nation. Today, we have several issues affecting the interests of the citizenry of this nation, particularly the recent elections we had in 2020 and the post-election petition that has been with the Supreme Court. We are not going to discuss the merits of the Supreme Court's case. However, we are going to attempt to educate the general public to clearly understand what is before us, so that whatever decision comes in the future, we will all have an open mind to understand the developments. I would also like to plead with all of us to remain patient and also ensure that we do not pass comments that would land us into any unnecessary challenges. I should say that the Progressive Intellectuals is not happy about the attempts by agencies of state to intimidate the media in particular and freedom of speech. We have come a very long way, and we expect that we have free, fair deliberation, have a discourse on issues that affect all of us, so we can collectively contribute towards the transformation of this nation that will ensure better conditions of life of the citizenry. On that note, I'd like to invite Lawyer Albert Kwesi of UPSA to take the stage and give us his presentation. Lawyer Koshigan is to talk to us about judiciary as the anchor of democracy.
Okay, thank you.
Excuse me, I've once again said that I'll take anybody who is disturbing us unnecessarily without muting his or her mic off. So kindly mute your mic and ensure that we let there be smooth flow of the discussion. Lawyer Koshigan is going to talk to us about judiciary as the anchor of democracy, reflections on election jurisprudence. Without much ado, I'd like to invite Lawyer Albert Koshigan to give us his presentation. Thank you very much.
Thank you. Thank you very much, Professor Gavoa, for introducing me. I am indeed grateful for this platform. I'm aware that it's a platform that has been created by the progressive intellectuals, which, as you have already said, is a collection of intellectuals across many tertiary institutions across the country. And so it speaks to the platform which you have created today. I also want to actually apologize for yesterday. I think yesterday I should have made my presentation, but because of technical challenges, I could not do that today, but I do that yesterday. But I'm glad that today I'm here to do that. I'm aware that ordinarily, Mr. Kwesi Pratt would have been the main speaker for today because he was billed to do the speaking today, but I've had to do this before him. And so I may have to go a little faster than I would have loved to go so that he can come in and do his presentation. But as has been said by Professor Gavoa, as he was introducing me, there's a broader theme for this two-day conference that we are having. Mine is just it's a topic, it's a sub-theme under the main theme. And as he said also, it's the judiciary as an anchor of democracy. Reflections on election jurisprudence. Now, if you look closely at this theme, you find out that they are in two broad parts, and each part is capable of taking a whole conference presentation. And so one part is dealing with the judiciary as an anchor of democracy, and then the second part is dealing with the reflections on election jurisprudence. Now, the first part provides the opportunity for me to actually affirm, looking at the various historical epochs in our historical epochs, whether the judiciary has been an anchor of democracy, and in fact, how the judiciary has succeeded in actually being an anchor of democracy. And then the second part, my intention is to talk about election jurisprudence, but I'm going to focus on presidential election petitions and how courts across the world have decided on such presidential election petitions. Because I'm aware that in a few days, probably tomorrow or tomorrow next, the Supreme Court of Ghana will be giving its judgment on a petition brought by former President John Dramani Mahama, against the Electoral Commission, as well as the sitting president of the Republic of Ghana. Now, so I like to begin by tackling the first part, that judiciary as an anchor of democracy. Now, I want to begin by asking a question. And the question is this: how has the judiciary been an anchor of democracy over the period? And I want to say that the judiciary has done this through the power of judicial review.
Albert, you are muted. Unmute, please.
Okay, good. So so the point I'm making is that I am seeking to look at how the judiciary has been an anchor to democracy, and then I'll look at the second part of the topic also. Now, I'm saying that the judiciary has been an anchor through the use of judicial review.
Zoom call, so I'll call you later.
Judicial review. And
I'm on a Zoom
now,
call.
judicial review
I'll call you
itself is a concept.
I'll send you the coordinates.
America.
Excuse me, Albert.
Yes.
I am going to mute everybody, and
Yeah,
then you unmute yourself when you want to speak. Thank you very much.
I think so. I think you should do that. Yes. Thank you. All right.
Yes, Albert, unmute yourself and go on.
Okay, good. So I can do that. So now I was making the point that the judiciary has been an anchor of democracy through the use of the concept of judicial review. It's a key instrument the courts have used over the years and probably the centuries. And the concept of judicial review itself is something that we have borrowed. And the concept is traced to the United States of America generally. And it first came up in the case of Marbury versus Madison. I believe that a lot of students have heard about this case and they know what this is all about. Now, when the concept of judicial review came up in Marbury versus Madison, I mean, it was understood in a narrow concept, actually, or from the narrow perspective, which means that it was the power of the court to inquire into or review legislative or executive act, basically, to be able to review executive or legislative act. But over the years, it's received an expanded scope. And I know people like Professor Kofi Kumado and co have spoken about this, that, you know, judicial review is now an expanded concept, and it's understood to mean basically the power of the courts to adjudicate on all disputes. And so when I say that the judiciary has been an anchor through the use of judicial review powers, the point I'm trying to make is that the courts have had the power, you know, to adjudicate all disputes. And as you are aware, the matter before the Supreme Court is a dispute between parties. And so what the Supreme Court is doing in the exercise of its powers is in a broad sense, judicial review powers. Now, but for me, what is significant is when you mention judicial review, two things come to mind. Now, the issue of judicial assertiveness comes to mind. That you have a judiciary which is not afraid or is fearless to tell truth to power or apply the law in a way, it even means that heavens must fall. In other words, the law should be applied irrespective of the consequences. And it doesn't matter, especially who actually, you know, has appointed you to a particular court or the other. You must just do justice in that respect. And that's one of the key things that comes to mind when you talk about judicial review. Now, the second part, or the second thing that comes to mind is that in the pursuit of judicial review powers, justice must also be served the people of the Republic of Ghana. Now, in the pursuit of judicial review, justice must be seen. And that's also very, very important. So I'll touch on these two things very quickly. Now, I mentioned judicial assertiveness and then justice. So if you must reach the end of justice, then you must have an assertive judiciary. And if you look at the historical epochs we've had in this country, and I really want to begin from 1957, when we had our independence constitution, and we went on to 1960, and all the way to the period before 1992, there were some flashes of, you know, judicial assertiveness across the cases that were determined in the courts. For instance, they were far and in between. So you don't see a clear pattern of judicial assertiveness. Although, as I've said, there are one or two cases in which, you know, for instance, the courts took a position and was able to stand up to a certain attempt by executive to influence or do something else. Now, my concern is the period after 1992 when it comes to judicial assertiveness. And I can say without a shadow of doubt that if you were to look at all the cases which came to the courts, the Supreme Court especially, soon after 1992, when we actually promulgated our 1992 Constitution, you'll find out that most of the cases which went to the court, for instance, there was a certain pattern. There was a certain pattern in those cases. And it was quite obvious what the judges were doing at the time. And as I've said, there are many of those cases which the courts decided. And without boring you, I mean, you will hear of cases like the 31st December case, where, for instance, the issue arose whether or not the government of the day could continue to celebrate, an event which actually overthrew a legally constituted government. And the court at the time said that, you cannot continue to hold that day as a public holiday. But don't forget the times in which the courts were doing this. The courts were doing this when the man himself, Judge Rollins, may so rest in peace, when he himself was the one who actually, set up this whole democratic architecture and probably appointed most of the justices to that court. So the courts at the time were actually bold to tell the truth to government. And in fact, to even some state departments. Now, even if you take another case like MPP versus GBC, for instance, that was a case in which the Supreme Court, was actually able to say that GBC was in breach of some law because they failed to give the opportunity to the MPP to also express their divergent view on a particular budget that had been presented. And the pattern continues. So I'm saying that before 92, there were flashes of judicial assertiveness, but the period after 1992 was profound. And many of the cases will show that although the one who set up the architecture was still in power, the courts were not afraid to tell exactly truth to the executive in terms of the law. Now, there's also another very important case in which, for instance, the issue of executive immunity came up. For instance, whether the president was immune to suits in the performance of his executive functions. The Supreme Court at the time said that the president, in the performance of his executive functions, could be sued, but he could not be sued in his name. He could not be added to a suit, but those suits could be brought against the AG. These were very phenomenal cornerstone, principles established by the Supreme Court. Soon after 1992, and then a little to 2000, 2005, thereabout. So a lot has gone on in terms of judicial assertiveness. And I'm saying that most people in the country today relish the opportunity for us to go back to those days when a Supreme Court, in a review or in the exercise of its powers, can tell the executive or the legislature what the state of the law is. Because as said in the case of Marbury versus Madison, when it comes to stating the position of the law, it is clearly the province of the judiciary, and nobody else has that power. So that's my first point on judicial assertiveness, that before 1992, there was no clear pattern, but after 1992, there was a clear pattern. And I know people who have spoken to me actually missed those periods and are confident that maybe in the future, we can get back to the period where the judges were able to speak to the law, even if heavens must fall, even if they needed to, go against people who actually appointed them to various Supreme Court offices, basically. Now, the second part is that when the courts are exercising judicial review powers, it must lead to justice. And that is very, very important. You see, because justice is the bedrock of our democracy. It's the bedrock of our democracy. And so if we do not hold on to justice, equity principles, treat like situations alike, then we are going to run into serious trouble. And now, so I want to make a few comments on the issue of justice, because justice itself is kind of an elusive concept and people have approached it differently. But there's one thing which is clear, that when you and I see justice, we see justice, we know it. In the same way, when we see injustice, we know this is injustice. But the problem is when you have to, give it a certain meaning. But when you see it, you know. So in a book that he himself has actually written, I mean, in doing this, I've been trying to look at a number of things and all that. Now, in his book, the role of the Supreme Court in the development of constitutional law in Ghana. Now, Dr. Bimpombuta, may so rest in peace, at page 8 of that book, discusses the importance of democracy and how justice is the bedrock of that democracy. That is the bedrock of that democracy. That's the bedrock of that democracy. Now, just indulge me for a moment. Let me just quote. I do not want to misquote him. Let me quote exactly what he said. Now, he says that the term democracy and its twin subject, good governance, have attained national and global significance and meaning. Now, in discussing this, he actually quotes a statement made by former Secretary General of the Commonwealth, of the Commonwealth Secretariat, Don McKinnon, because Don McKinnon was also speaking about democracy, and he was commenting on the threat to democracy. I'm just to build a point. Now, he quotes Don McKinnon and says that the promotion of democracy and good governance is the key to improving people's lives. And the growing gap between the rich and the poor is the most powerful destabilizing force and the greatest threat to democracy. That's what Don McKinnon said, that the growing gap between the rich and the poor is the most powerful destabilizing force and the greatest threat to democracy. Now, but this is what Bimpombuta thinks about this statement. Now, he goes on to say that is respectfully agreed, and he agrees with me, but he goes on to say that, but it should be further observed that an even greater threat to democracy is the injustice meted out to citizens by the application of the laws and the legal system in developing countries in Africa like Ghana. I'd like to take that very profound statement. Don McKinnon has said that the gap between the rich and the poor is a threat to democracy. But Bimpombuta, may so rest in peace, has gone on to say that, of course, that is true. But it should be observed that an even greater threat to democracy is the injustice, which is meted out to citizens by the application of the laws in a legal system in developing countries in Africa like Ghana. So you can imagine, that's Dr. Bimpombuta, his stature and standing in the legal front cannot be controverted. And that is what he thinks about the application of laws in this country. And that's what it is. So for me, justice is the bedrock of this democracy. And this means that the laws must be applied equally to all manner of persons. Now, before I run up on this somehow and then move on to the second part of the topic quickly, because I know that Uncle Pratt is waiting, let me say that actually there's a slight passage I want to refer to because it brings up a certain element that I want to talk about. You see, and I'm actually quoting from the works, or I'm reading from the works of Mr. Lewis Carroll. In his work, Alice's Adventures in Wonderland. I think somewhere in 1907. I think most of you know about this, Alice in Wonderland. And look at the discussion that went on between the king at the time, Alice herself, and the queen. And then you see the point about equal application of rules to equal groups of people. It's very important. Now, this is how, and I'm reading, it says that at the moment, the king, who had been for some time busily writing in his notebook, called out. He said, "Silence," and read out from his notebook, Rule 42, in quote, "All persons more than a mile high to leave the court." That was the king. All persons more than a mile high to leave the court. Now everybody looked at Alice. Then Alice said, I am not a mile high. Then the king said, you are, said the king. Nearly 2 miles high, added the queen. Well, I shan't go. At any rate, said Alice. Besides that, it is not a regular rule. You invented it just now. The king said, it's the oldest rule in the book, said the king. Then it ought to be number 1, said Alice. The king turned pale and shut his notebook hastily. But this is the point, that Alice had gone to somewhere, and the king was seeking to administer justice in his court. But when the king saw Alice, Alice was not like all of them. So he quickly tried to make a law to apply specifically to only Alice, and said that if you know that you are here and you are more than a mile high, means that you are taller than 1 mile vertically, you should leave the court. Alice looked at it and said that, no, I cannot leave, because the law you are talking about was not already in existence. You just made it only for me because you wanted me out of the place. The king said, well, that rule I'm applying is the oldest rule in my book. Alice says, then that rule should have been number 1. But if you look at the rules book that the king was using, that rule was not there. So the rule had just been invented to get to Alice. But that's the question. Was the king supposed to apply a different rule to Alice because she was a mile higher? Or he was supposed to apply the rules which apply to all his subjects? Now, this is a question I like to put before I go on. I mean, do you want to be an Alice? Do you want to stand up to those who exercise judicial authority and say that we think that this kind of rule is wrong or it is right? But I leave that to you. I leave that to you. But the point I'm seeking to make is that it's very important that in excess of judicial power, whether it is in the determination of an election petition or any other, adjudication, there must be some fairness in the application of the rules. Now, when justice is being administered, justice, those who administer justice must be blind to a lot of considerations, whether it's political, whether it's a family relation, whether it's a business relation. Those who administer justice must be blind. So no wonder, and I believe most of you have seen the allegorical, the symbolic, or the symbol of justice, which, I think most of you have seen around. You see a female who is wearing a blindfold. She has a scale in the left hand, and then she has a sword in the right hand. Now, the blindfold tells you one thing, and probably she's wearing, a long robe called toga or something. Now, what this allegorical depiction of justice tells you is that as the one who dispenses justice, when you are dispensing justice, you must be blind to everything else. So you must close your eyes. To the extent that even if you must apply the rules, or you must do justice, you must do it even if heavens must fall. You must do it without personal considerations, amongst others. And so in fact, this position has been reiterated in many cases, which are only now persuasive on us. But if you look at one case like R versus an ex parte McCarthy, which is R versus Success Justices, it's an English case. That's the case in which that statement has come out from. That, you see, justice must be done, even if the heavens must fall. Which means that if you must do justice and the consequences must follow, you must do it. And sometimes the consequence might include losing friends, political friends. It might include losing family. but you have to behave like the allegorical, symbol of justice, which is blind to all kinds of consideration in the dispensation of justice. Now, having made this point, I believe that given the time frame, I've just dealt with the first part of the topic, which is talking about the judiciary as an anchor. So there's no doubt that indeed the judiciary has been an anchor over the period, and they have done it through the power of judicial review. But I've also made the point that if you were to choose any historical epoch in this country to make a definite statement that this was a period in which the justices, they were blind to all kinds of considerations, including those who appointed them to the Supreme Court, amongst others. The period is soon after 92, probably to 2000, and a little beyond that. Now, and I've said before, most people relish that period, and they want that period again in our country. Now, having dealt with that, let me move on to the second part of the topic. It has to do with election jurisprudence. Now, elections include all kinds of elections, parliamentary elections, the presidential elections. But my concern is to deal with the jurisprudence or the line of thinking of courts when it comes to deciding whether to annul an election outcome or not to annul an election outcome. And this is without prejudice to anything which will happen tomorrow or tomorrow next. Now, there are, and as you have seen, there is now a principle which I think most people have come to accept, that in order for a court to be able to annul an election petition, there must be a two-stage process. And that two-stage process must be accomplished by the petitioner. One, the petitioner must show that there were irregularities or there were violations of law. But that's not enough. You must go to the second ground. You must show that the violations of law resulted in illegal votes, which are sufficient to change the outcome of the election. This is the two-pronged step that you have to go through as a petitioner. Now, let me say that this principle it began in 2000 in the case of Bush versus Gore. Now, in Bush versus Gore, I think a lot of people, had followed the events at the time. Now, Bush versus Gore was an interesting case because at the time, the Florida, American American system is federal, so they have state courts and they have federal courts. Now, the Florida state had a state law which had provided that for an election to be set aside, you ought to show that one, there were irregularities. Two, the irregularities resulted in votes, which, if deducted, can change the outcome. That's a Florida state law. It was based on this law that Albert Gore fought the battle all the way to the state court in Florida and then got a judgment in his favor. So the Florida state court had said that there should be a manual recount of some of the votes. Manual recount of votes in some counties in the United States. Now, what the Florida state court did not do was to provide a standard for counting these votes manually. I think quickly, President Bush and his vice president went to the federal Supreme Court to raise an issue of equal protection. The argument was that the Florida state court made an order for recounting, manual recounting, but did not provide a standard for counting. The court upheld and said that, there should have been a standard for manual recount. And the concern was that because there was no clear standard, the votes in one county were likely to be treated differently from the votes from the other counties, which meant that each vote, some votes were going to be degraded in quality as compared to other votes in other counties. And that's how come Bush became president in 2000. And that's how come he won the case. So that principle I call the sufficiency principle. Now, that principle has been applied in several other cases. And I will wait to see, but there's one other case, which is a Canadian case, which is Opitz versus Wachinski. I think it's a case which has featured mostly. In that case also, the same principle was applied. That one, were there irregularities? Two, did the irregularities result in illegal votes? Now, if it did, will the votes, if taken out, change the outcome of the elections? In that case, they applied the principle, and it worked, because the winner in that election won by only 26 votes. And it was established that there were irregularities, and the irregularities resulted to over 70 votes, for instance. Now, if you were to take 26 out of 70 something, I mean, you can see that there was no winner. So that principle was applied. Now, since then, in Africa, we have applied those decisions in Kenya. Sorry, we have applied those decisions in Zimbabwe. We have applied those decisions in Nigeria. We have applied them in several other countries where people have found it fit to go to court to actually annul an election. So from that period until, let's say, 2017 up till now, that had been the jurisprudence of the court. You must first show that there was irregularity, and some votes resulted from that irregularity, and if those votes were taken out, the outcome will be different. But you see, there's a problem with this particular principle, because then what we are saying is that we are legitimizing a certain degree of irregularity in our elections, especially so when you look at the huge sums of money that is given to electoral commissions to run elections, and the fact that they have never wanted money that they have never had. You are lowering the bar for electoral commissions to say that, of course, irregularities are acceptable, but be careful that when they occur, they do not change the outcome of the elections. That's the problem with that jurisprudence. But thank God, quite recently, things have been changing. Now, if you have followed the Kenyan Supreme Court decision, for instance, you'll find out that, I mean, Uhuru Kenyatta won an election sometime in 2017, but that election was overturned on grounds of irregularities. And that principle did not work much in that case, because as far as the Kenyan Supreme Court was concerned, were there irregularities, even if included vote padding and other things, were there irregularities? Two, did the irregularities undermine the entire integrity of the election? That was what was important to that court. So it is immaterial whether some figures will change the outcome or not. Once you can show that the elections were irregular in some parts, and the irregularity was such that it's the integrity of the elections, you must annul an election. So you see that Kenya has moved away from that existing jurisprudence to say that every time there must be a figure and all those things. Now, even more recently, the Malawian Supreme Court has done something. And for me, that's the most current precedent that we know of election issues. And if you read that case, it tells you a lot of things. Now, the Malawi Supreme Court took its time to review these approaches. The approach which was used in Bush versus Gore, which was used in Opit, which was used previously. And the Malawian Supreme Court was categorical that elections were serious businesses. And it was unacceptable to condone even the slightest form of irregularity. As a result, the Malawi Supreme Court did not have any hesitation at all to annul the elections, the presidential elections of 2020. Now, they did analysis of the approaches to annul an election. And they looked at the quantitative approach, and that's more like what we have applied in 2012 in this country. And that's what Nigeria has applied. That's what Zimbabwe has applied. That's what Bush and Gore applied. That's what Pitt applied. So that's the issue. Now they reviewed all those and came up with about 3 approaches that should be used in deciding to annul an election result, not to annul the results. Now they looked at the quantitative approach, which has to do with the numbers. Then they also looked at the qualitative approach, which has to do with irregularities which were such that they undermined the integrity of the election. And then they said that, well, I mean, there could be a hybrid. So in the Malawian situation, they applied everything, including figures, including irregularities, that is violations of laws, either the constitution or the electoral laws of the country, and they annulled it. Now, for me, I think that we have to be moving away from some of these things. Now, I've been following the case, and I've seen that, you know, the key points that petitioners have made is that on the 9th of December 2020, when the Electoral Commission declared Nana Addo Dankwa, the current president, as president-elect, given the entirety of the circumstances, none of the candidates got 50% plus 1, as required under Article 63 of the Constitution. So that statement, which was made, in fact, they also alleged that there were vote padding, amongst other things. But these were all small irregularities taken together. Now the respondents generally are saying they complied with law. And if you follow the pattern of cross-examination, you'll find out that, and I've heard Senior Kutompa put it across many times that, I mean, the figures of vote padding were so small, they were not enough to change the outcome of the election. So a vote of over 5,000 individuals, you know, and even in America, in Bush versus Gore, the votes were so small. But here we have 5,000 votes. But the thinking is that because it cannot change the outcome, because the point is that the current president led by over 500,000 votes, and 5,000 can't change the outcome. But it's acceptable that there's a certain degree of irregularity. So that's the issue, that we have to be moving away. We cannot continue to endorse irregularity, no matter how small it is. Now, just by way of rounding up, let me just come to our own 2012, you know, presidential election. Now, as I said, in 2012, the court applied this principle, but I think there were some of the judges on the panel who were prophets. They were actually prophets, and I've read that over and over again, and I've considered, and for me, I mean, in terms of citing examples, the current Chief Justice is the biggest example I can cite. Now, if you read the judgment of Justice Eniyebua at the time, now the Chief Justice was actually prepared to annul elections based on, for instance, you know, annul based on some violations. For instance, one of the key issues in 2012 was that the pink sheets had not been signed by presiding officer. I was like, what's one of the key issues? Now, on that issue, Justice Eniyebua actually was prepared to consider and say that that's not an irregularity we should accept. And he upheld the petitioners on that particular matter. And some other justices also did the same thing. I mean, except for Justice Tuguba and Justice Adinira and others who dismissed all the grounds for the petition. I mean, some of the judges considered that even if the irregularity is so small, you must actually deal with it in a certain way. And I think for me, that was very progressive at the time. And so even before other courts, even before Malawi was thinking about, dealing with these matters without considering too much figures, I mean, our own justices have been thinking about this way before now. And so for me, this is significant. And I think that we have to move forward. We cannot continue to endorse, you know, illegality or violations of law, no matter how small that violation of the law is. Now, let me just give a small, passage from the ruling of the judgments of the Supreme Court in 2012, and precisely what one of the justices said, and she's currently the Chief Justice of the Republic of Ghana. Now, this is what he said. I am of the opinion that no matter the number of votes involved that may constitute overvoting, it is a clear illegality and should not be endorsed by a court of law, more so by the highest court of the land. I will therefore proceed to annul all votes which were proved by the petitioners to be so. So you see, this is what the judgment is saying. So I think that Justice Eniyebua was a visionary years ago, and he knew where we were going to as a country. 2020, Malawi has put beyond doubt. Kenya has put beyond doubt that we cannot continue to endorse irregularity. We give so much to electoral commissions that they must account for every penny. They must account for the performance of every public function that they indulge in. So basically, this is the point I'm seeking to make. Now, I've just tried to make 2 points. The first point is that the judiciary has been a key part of democracy, probably the integral part of democracy. And that I've also made the point that it's very important that the judiciary is assertive in deciding on some of the matters, even if it means that justice, even if it means that, I mean, the heavens must fall. That must be done. Then the second part, I've tried to look at what the jurisprudence is until now. My conclusion is that Africa is moving towards a certain degree of high standards. We, at this point, cannot, do anything different from that. We have to move forward. And so we wait to see the outcome. Which of the approaches that the court will use? Will the court use the quantitative approach, simpliciter, or the court will use a combination of the quantitative approach and the qualitative approach? We wait to see. But basically, this is my presentation for this afternoon. Thank you very much for granting me audience. Thank you.
Thank you very much, Lawyer Kwesi. I should say that this presentation has been very spirited, straight to the point. It is not an exercise, it is not only an academic exercise we are engaging in this afternoon, but an exercise in making us meet our social responsibility as citizens of this nation. Any intellectual exercise that does not translate in the improvement in the conditions of life of people is meaningless. So we have been advised that justice should not only be seen, but those who administer justice must be assertive. In doing so, they must be fearless and apply the law in ways that, irrespective of the appointing agency, they will still deliver, or they will still be seen to be delivering justice. And we should administer justice without personal and factional considerations. We cannot continue to endorse irregularities and violations of the law in our country, lest we develop a failed state, which we can afford to have now. We must be mindful not only of ourselves, but the generations after us and the future of this nation of ours. Thank you very much, Albert Kwesi. We'll be having a discussion at the end, but for now, let me kindly invite Comrade Kwesi Pratt, a student of history, particularly a student of Ghanaian and African history, to give us his presentation. He's going to share knowledge and experience with us. I know that although we say this has been organized by progressive intellectuals, in my country, I have encountered so many intellectuals that are not educated about our country, who we are, where we are from, and where we intend to go. This is a program that is to offer us education. It's an exercise in public education. We can limit it to ourselves. So whatever we hear today, let's take good notes, mental notes, written notes, and ensure that those who have not been able to join us will benefit from the experience. Thank you, and let's all welcome Comrade Kwesi Pratt.
Well, comrades and friends, good afternoon. First of all, I must express my deep gratitude to this intellectual forum for allowing me to contribute my views and ideas in such a technical discussion. I'm fully aware of my own limitations, and I shall try to make a presentation which would take notice of my limitations as a layperson when it comes to the law and so on. This afternoon, my charge is to speak on the principles of the law and society, and also to take a peep into the future of our country, Ghana. I'd like to start, first of all, by looking at what is the law, how the law is made, the role of the judiciary, and who are those who become judges. Then to look at questions of accountability when it comes to the interpretation of the law and the functioning of the judiciary. I may also attempt to look at the laws of contempt and so on, and then also look at the role of other state and non-state institutions and organs in shaping the law and shaping the destiny of our country through the judiciary. And then finally, I'll take a look at the presidential election petition which is before the courts now. And I shall do so in a manner which would not be regarded as offensive to the court and therefore bring problems to us, as the chairperson indicated from the beginning. Now, I think it's absolutely important that we note that the law essentially defines society. The law is about who we are. The law is about the regime under which we operate. The law defines our society. In converse, you would also find that if you were to look at the law, you'll be able to describe the kind of society in which we live. So, for example, in the era where the principle of the divine rule of kings operated, the law recognized rulers as direct ramifications, it has its own import, and so on. You would also recognize that under Hitlerite fascism, the law recognized fascism as the established order, and the law and its institutions, the judiciary and so on, compelled people to obey fascist law. It's also true that under classical colonialism, the law was shaped and fashioned in a manner which compelled obedience to colonialism and so on. Of course, in the era of the transatlantic slave trade, slavery was glorified by the law and protected by the law, and people were forced into compliance with the laws which guaranteed slavery and so on. So it's important that we take account of the fact that the law has never been neutral. Indeed, given the nature of the law and the nature of the processes which go into formulating the law and enforcing the law has always been a tool in the hands of the dominant forces in society. And the dominant forces in society have at all times used the law in order to entrench their rule and to exact obedience from the rest of the population and so on. Now, one may ask, how are laws made? How do laws come into being? In our particular circumstance in Ghana, we are told that the laws are made by Parliament. Parliament has the powers to enact laws and so on. But we also do understand that the judiciary operates in a certain way which allows them indirectly also to make laws. For example, precedents set by the Supreme Court, for example, are binding on lower courts and so on. Now, if precedents are by themselves law, then it will stand to reason that the judiciary itself has a law-making role. And I think it's important that we take account of that. The fact that the judiciary by itself is able to set precedent, which precedent to a very large extent has the effect of law and so on. Now, what is the role of the judiciary? Yes, one of the roles of the judiciary is to serve as arbiters in disputes, such as we do have in the Supreme Court now, where there's a presidential petition before the Supreme Court for consideration. The judiciary also appears to have a responsibility for maintaining the status quo in society. The judiciary has a responsibility for the interpretation of the law and so on. But those of you who are lawyers would also tell us about the principle of purposive interpretation of the law. And I'm told as a non-lawyer that the principle of purposive interpretation of the law is simply a principle which emphasizes the fact that in interpreting the law, judges ought to be careful not to upset society, not to destroy society, not to interpret the law in such a way that it may lead to chaos and violence and so on. That they interpret the law in such a way that it enhances the values of society, that it promotes the well-being of people in society, and so on. Now, there's a very important question about who judges are. Who are judges? Whether they sit on the High Court or they sit on the Court of Appeal or the Supreme Court, who are judges? And here I'd like to make reference to the basic principle that you find in any democracy or anything that pretends to be a democracy. And that basic principle is the principle of the equality of citizens. The quality of citizenship is not different from one person to the other in a democracy. Indeed, nobody has a citizenship which is more qualitative than the other, and so on. Now, if you apply this principle, it will simply mean that judges are like all of us. They are human beings and so on. And indeed, we have seen over the years that judges are not substantially different from the rest of us. They have their religious beliefs. Some of them are Muslims, some of them are Christians, some of them may be Buddhists, some of them may be atheists, and so on. So to that extent, judges are just like the rest of us in the population. And if we have religious convictions and so on, those convictions may find expression in the kinds of judgments that we give and so on. Now, we come from different social backgrounds, as judges also do come from different social backgrounds. And these different social backgrounds also inform our decisions as non-judges, but they also inform the decisions of judges and so on. Of course, we may have different political affiliations, either open direct affiliation or affiliation which is derived from our consciousness and so on. We all have these different political persuasions and so on. And all of that influence us in the day-to-day conduct of our affairs, in our official capacities and so on. Now, it would seem to me that we do recognize that. And that is why as we go higher and higher on the ladder of the judiciary, we have taken steps to ensure that no one person's decisions will be binding on all of us. So, for example, at the level of the Court of Appeal, you have 3 judges sitting on the case instead of 1, which you'd find in the High Court. And then in the Supreme Court, you may have 5, you may have 7 judges. And indeed, where there's a review, you can go up to 13 and 15 judges and so on. And it would seem to me that the principle here is that all of us, judges and non-judges, are fallible. And because we are fallible, the addition of numbers perhaps may help in curbing our excesses, in curbing our biases, and so on. So it is important to recognize that judges are not angels descending from outer space, and that they are like us. They live in our society, they are shaped by our society, they function to express biases that all of us do have. It's important that society takes steps to minimize the impact of these biases and so on. Now, it will be strange if we set up institutions that are wholly unaccountable to the population. And in relation to the judges, to the judiciary, even to the Supreme Court, I would like to submit that they sit in judgment in the name of the people of Ghana or the people of any country in which they sit in judgment. The judges have no powers which were given to them by God. The powers they exercise are the powers we find in the 1992 Constitution in the current instance. The judges exercise powers which must necessarily be derived from the people. Now, what is interesting is that our judges are not elected public officials. Indeed, they are appointed public officials. But even as they are appointed public officials, it is clear that they sit in judgment, they sit in arbitration on behalf of the people. And if they do that, then it is important for our judges to take into account what our people want and wish for. That's important for them to take into account, indeed, what the aspirations of our people are. It's important for them to begin to realize that they are not lords unto themselves and so on. It's absolutely important that our judges realize that. Now, how do we hold our judges accountable? For example, if you take the Supreme Court, and in this instance, the presidential election petition, we are told that the Supreme Court will come up with a verdict probably tomorrow or the day after. And that after the verdict, the party which may be dissatisfied with judgment can indeed go for a review. We are told that even that review must satisfy some conditions. The court itself must grant permission for that review to be held and so on. And we are told that after the review, the matter is closed. The matter is closed after the review. Now, over the last week or so, there has been an interesting development in the Ghanaian media, in the Ghanaian public. I've seen all manner of people, including prominent chiefs, including faith-based organizations, sometimes including even highly respected lawyers and so on, who have come forward and told us that whatever the decision of the court is, we must accept it in good faith. And we must not protest and so on. And I'm sitting down asking myself, these highly respected people, do they know something that the rest of us don't know? Because if they take the stand that whatever the court decides we ought to accept, perhaps they do know something that the rest of us don't know. Because I'm fully aware of the injunctions in the 1992 Constitution, which calls on all the people of Ghana to resist oppressors' rule with all the tools at their disposal. I'm fully aware of the injunctions in the 1992 Constitution, which tells us that those who want to subvert the Constitution itself need to be resisted. I'm fully aware of the injunctions in the 1992 Constitution, which says that we must do everything and anything to preserve the constitutional order. Now, we don't know what the Supreme Court is going to say. Just in case the Supreme Court came with a decision which is subversive of the Constitution, are these faith-based organizations and prominent lawyers and organizations telling us that we ought to be accepting violations of the Constitution or things that undermine the Constitution? In any case, are we being told that judges are infallible? That would be strange. In the light of the Anas findings on tape, and on the basis of which the court itself has taken action. So judges cannot be infallible. And if judges cannot be infallible, if judges can make decisions which may be inimical to the collective interest of the people of Ghana, if judges can make decisions which can undermine the 1992 Constitution, why don't we wait for the judgments to decide whether indeed that judgment is meritorious enough for us to accept or not to accept? So all these calls on all of us, to bow down in obedience, to accept whatever the judges decide and so on, is very strange. It does not seem to me to be coming from forces which are interested in the preservation of the democratic order. It does not seem to me to be coming from forces which recognize that all human institutions are indeed fallible. And because they are fallible, they can make mistakes. It seems to me that those who are urging us to accept whatever decisions the court would make have taken us years back into the era of the divine rule of kings, except that this time they are telling us to accept the divinity of our judges, the infallibility of our judges. And I think that's clearly unacceptable and so on. Now, in the course of the proceedings, one of the things which has come up very, very strongly has been the application of the law of contempt. And only last week, we all read and saw the statement issued by a law firm allegedly on behalf of the Judicial Service. Now, that law firm, or the Judicial Service, as the case may be, directed media practitioners to pull down offensive material, you say insightful material, hateful material, and so on, from our platforms. And what is interesting is that we were not told what those materials are. There was a certain vagueness about the materials and so on. And then we were told that if we didn't behave well, we could end up facing serious judicial consequences and so on. Now, the view has been expressed by lawyers and non-lawyers that perhaps the time has come to codify the laws of contempt. So that when we talk about contempt, we know exactly what we are talking about. What is it that constitutes contempt? What does not constitute contempt, and so on. This acceptance of a situation in which we are told that when it comes to the law of contempt, the law lies in the bosom of judges. How can you live in any society like that? What bosom are we talking about, and so on? So it's important to begin to discuss these matters and so on, having regard to the fact that the threat of hauling people before the courts of contempt can itself be used as an instrument to subvert the right of free expression of our people. It can be used to stifle free expression. And therefore, it becomes important for us, to deal with these matters. Now, in all the cases of contempt that I'm familiar with as a layperson, the judges act as policemen. They act as prosecutors and also act as judges. This must be clearly unfair. And this is an issue which should concern all of us. And all of us need to find ways of ensuring that we deal with this issue of contempt and so on. Now, it is important for us to remember that not too long ago, even our judiciary was suffering under the jackboots of military dictatorship. We cannot forget that not too long ago, we had public tribunals in this country which were not subject to the decisions of the Supreme Court, and whose actions and decisions were not subject to the review of the Supreme Court and so on. Now, what happened? Civil society organizations, individuals, political organizations, and so on, came together and struggled for a return to the old judicial order in which the Supreme Court became the apex court of the land and has supervisory responsibility over all tribunals and so on. Now, it's important for the Supreme Court and its judges, for persons in the judiciary, to understand very clearly that even the powers they enjoy today are the results of popular struggles by individuals, by civil society, and so on. And if indeed their own powers and privileges are the results of popular struggles and so on, then they ought to be paying attention to the space for popular struggle and popular expression and free association and so on. Because ultimately, if they contribute to subvert the right of free expression and the right of free association, ultimately, if they contribute to closing the space for civil society and mass organizations and so on to act, in the final analysis, all of us, including the judges and the judiciary, would suffer the consequences perhaps equally. So it is important that we recognize the role of all of these institutions and so on. Now, going forward, what kind of future do we see for the judiciary and society? I want to see a future in which the judiciary enjoys the respect and confidence of the population. I want to see a future in which the judiciary is an ally of the forces of change and justice. I want to see a future in which the judiciary sees itself as a participant in the struggles which would enable the people to control their resources and to exploit their resources in their own interest and for their own benefit. I want to see a future in which the judiciary is a partner for development. I want to see a future in which the judiciary is not part of an authoritarian structure whose main objective is to cow the people and enable their rulers to thrive while the people perish from poverty, from ignorance, from hunger, and from lack of access to social services. That is the kind of future I want to see for the judiciary. Now, finally, I'd like to talk about the presidential election petition currently before the Supreme Court. Indeed, the court can decide anyway. The court can decide that there have been infractions of the law. The court can decide that the conduct of the election was such as to invalidate the results announced by the Electoral Commission. The court can also decide that everything was fine, everything was beautiful, and that whatever the Electoral Commission did was in the best interest of the country. Indeed, the court can also decide that there were aspects of the elections which were not in consonance with the law, and that there were aspects of the elections which did not follow approved procedure, legal procedure, and so on. The court can decide either way. Whatever the court decides, it will be up to the court to make that decision. But when the court has made that decision, it will also be up to us as citizens to evaluate the decision of the court and to come to conclusions as to whether the court has been fair or unfair. It's important, however, to point out that in the determination of the petition before the court ought to be seen to be doing some things. I'm a lay person. I didn't go to Makola. I didn't go to Jimpa. I didn't go to Legon Law School. I'm just a very simple journalist. But the court is going to take a decision about which of our citizens should be made to manage national resources, including the National Treasury, for the next 4 years. That decision affects me. That decision affects my family. That decision will affect my grandchildren. That decision would affect the destiny of this country. And therefore, I have a right to contribute to making that decision. How do I contribute to making that decision? I contribute to making that decision by examining the decision of the court and satisfying myself that the decision of the court is in my best interest. And I should have every right to make that comment about the decision of the court. Nobody should be allowed to stop us from passing our own comments on the judgment as to whether it serves our interest or it doesn't serve our interest and so on. Indeed, it would be strange if at the end of the day, we come to the conclusion that the court was not interested in the material facts which can help it make a fair determination of the issue. The court itself has a responsibility to establish the material facts. If the court is not interested in establishing the material facts, how can we then accept the verdict of the court? What is the empirical evidence upon which the court makes a decision? So that's a very important ingredient that all of us will be looking for. In any case, this is a country which has promulgated laws, and one of the laws calls for transparency in public administration. Only a year or two ago, this country passed the law which grants access to information and so on, with the understanding that it's important for our people to have access to information held by public officials. And that indeed, information which is about public interest and held by public officials and so on cannot be withheld from citizens. Now, would there not be a contradiction if our courts now make the decision that such information should be kept as secrets and that citizens are not entitled to that information? Would that not be a contradiction in our values? And to what extent can that lead to the promotion of the principles of accountability and probity in public life? These are questions for all of us to ponder over. I'd like to thank you for listening to my rumble, and thank you very much. Thank you.
On behalf of the progressive intellectuals, organizers of this forum, I'd like to thank Comrade Kwesi Pratt sincerely for sharing his knowledge and experiences with us. As I intimated earlier on, this is an exercise in which we learn among ourselves and for the purposes of improving the life conditions of ourselves, our country, and Africa at large. We have heard that the law is what defines us. It defines our society, and it is all about who we are. However, the law in history has been used, and particularly it has been held in the hands of the dominant forces of society since the time of the enslavement and trade of people, particularly we Africans. It's something that has been held in the hands of the dominant forces to exact obedience among us. And it was applied during the colonial period. And now we are in the new colonial period. And sometimes we may witness the same. However, those who wield the law, those who administer the law, the judiciary must serve as arbiters. And those who are responsible for interpreting the law should interpret the law in such a way that it will not foment chaos. It is something which will not upset society and generate violence. We've also heard that judges are normal human beings who are influenced by belief systems, society, political ideology, and so on and so forth. So whatever decision they take will be influenced by all those. However, we have been reminded that the powers exercised by the judiciary are not personal. This is power that they hold on behalf of the citizens of this nation, through they hold on behalf of the citizenry, through the constitution, which the people have crafted for themselves. And so they must be seen to be serving in the interest of the people, the subaltern, the underprivileged as well, and not necessarily the dominant forces of society. We've also been reminded that our Constitution enjoins us to resist oppressors' rule and preserve the constitutional order in our country. But we have things that are threatening to stifle free expression of our sentiments, of our thoughts in the country, including issues of contempt, and we must guard against that. We've also been educated on how civil society organizations fought and struggled to restore the powers of the judiciary in this country when it was whittled away by certain circumstances. We must recognize the role of the institution and ensure that it performs its responsibility to our nation. With regard to the future of the judiciary, we have been informed that the kind of judiciary that we may wish for this country is one that is an ally of change and justice, one that supports and partners the development process, not one that supports the authoritarian structure, but one that ensures that citizens, the interests of the large majority of the citizens are realized, and not only something that would inure to the benefit of only a few in society. With regard to the presidential petition, we've been advised that the court is free to decide in its own right because they have the power to do so. However, we must have the freedom to express ourselves, our sentiments, as regards the decision of the court. And this stems from the laws of this nation. The court must establish the facts that influence its decision. And we should ensure that there's transparency in public administration, and that enjoins the court to let us know exactly what informed their decision. Short of that, we as citizens of this country have every right to ask for the details, for explanation of what decisions the court has taken. This has been very informative and highly educative. And I once again thank Comrade Kwesi Pratt, indeed a student of history, for his presentation. At this juncture, I would like to open the floor for our comments. But before then, may I acknowledge some of the media houses that have been invited. Joy News, Joy FM has been invited. We have TV Africa, Pan-African TV, we have XYZ and Ghana News Agency and many more. If they are with us, I would like to thank them very much for their patience. We hope that the message will not be limited to this virtual conference alone, but to be spread for many of our people to benefit from the knowledge we have shared this afternoon. Colleagues, may we have our comments, but once again, I'd like to crave your indulgence that we must be circumspect in whatever we churn out there, ask our questions, but ensure that we do not subject ourselves to situations where issues of contempt may be used to stifle our freedom. Thank you very much. Yes, I see a few hands up. May I take Hussein Sheikh?
All right, thank you very much for this opportunity. I want to thank the speakers, that is Lawyer Kwesi and Uncle Kwesi Pratt, but they have given splendid talk this afternoon, and we thank them so much. My question will be directed to Uncle Kwesi Pratt. Now, Uncle Pratt has made us aware that the judges, even though we say they are supreme, they are independent, but their works must be subjected to criticism. Now, let's say the judges and the Supreme Court delivers a judgment, and it is not in the interest of the public. What is the next step? What do we do as a country? A judge delivers judgment, that correspond with the interest of the country, from all the evidences, from all the public, should I say, outcry or public interest. What do we go? Where do we go next as a country if the Supreme Court comes out with a judgment that do not correspond with the interest of the country? Thank you very much.
We have another question, please. Audu Sani.
And thank you very much. I would like to say good evening to all the participants and also well done to the presenters. And my first question is that in the development of our democracy, is it the law that is more important or the justice expected by the people? 2, when justice is denied, don't you think that contempt and attack on the judiciary would become the norm? And is the law perfect? Thank you.
Thank you very much. May we have Julius Masley?
Yes, thank you for the opportunity and wonderful presentation. Now, my question is, when Mr. Pratt was speaking, he mentioned that the judges are appointed. Now, if these judges are appointed by a certain administration, has there been some sort of research to, as it were, ascertain if their judgment are skewed towards the appointing government? Because I can give you a typical example, Chachu against the state. We can all remember that President Kufuor appointed additional judges to examine his case. And even though he had won the first, the second was ruled against him because there was an additional appointment of 2 judges. Now, I want to know again, stress, if there is any research that tells us how these judges have conducted themselves over the years. Thank you.
Thank you very much. We'll take 2 more and then we'll permit the presenters to respond. Adam Kojo.
Yes, thank you, Comrade Pratt, and then Comrade Pashiga for a wonderful presentation. But I would like to, any of them can take the question, but I would like to ask the presenters. So we need to go back to the root of the problem, and the root of the problem is the appointment of the judges, and then we, as it is now, we don't even have any cap to the number of judges that can be appointed to the Supreme Court, for example. Now we have been told about the constitutional reforms that was done by the late President Mills, and then all those recommendations that we have with it. Now, if a progressive ally like the NDC comes to power, and we don't see any attempt to even enforce some of these recommendations, then where does it leave all of us? Because for me, that is the root of the problem. So can we address that issue? When do we see any commitment from any of these progressive forces when they're in power to try to do the right thing, so that we try to at least set the system right, so some of these excesses are not done? Because we cannot say for sure that judges are not influenced. As we can see clearly, they are influenced. And from the research by Professor Tukuba, which shows clearly that unless anybody has a contrary research opinion, that's what we have now. So we can address that issue. Thank you very much.
Thank you very much for your question. We'll have the last question, and then we'll Malik Abdul. Moses has been here already, so let's kindly take Moses, and then when we come to the next round, we'll have you. Moses Ajay.
All right, thank you, Prof, and good afternoon to all of the participants. In fact, my concern has to be with some of the rulings in this particular election petition. I am doubting, I'm wondering what we make of it. In this sense, when we say contempt, we've had several rulings already. I mean, sub-rulings of the main petition. One key one is for the petitioner requesting to interrogate the electoral commissioner, which were denied by the Supreme Court. That ruling denying the petitioner the opportunity to question the very person who announced whatever results we have to deal with now, that is a ruling. Are we allowed as a public to critique such things? And to what extent do our criticisms constitute contempt? I want the lawyer to advise on this particular. The case is running, all right, and there were some rulings. Those rulings, are we allowed to make our own views known on it? And would that be considered as contempt? Thank you.
Thank you very much. We have a legal person and a historian with us, and I believe that they will help us to understand the questions you have raised. So any of them can decide to take any of the questions with which he feels comfortable. Thank you. Albert and Comrade Kwesi.
I defer to Albert, and if Albert finishes with the questions.
Albert, since you are lawyer Albert Kwesi, there are some legal issues that I strongly believe you are able to help us to understand. Then Comrade Pratt will come from the historical perspective. Thank you.
All right. So thank you. It's not easy for Senator Kwesi Pratt to defer to you on matters. So once that is done, it becomes a very big burden. But a number of questions have been asked, and I'm not sure that I was able to capture all of them. But the last questioner, is actually concerned about some rulings which have been given so far, and whether we are allowed to comment and how far our commentary can go, such that we do not find ourselves in the clause of contempt. Now, I have to say, without an iota of doubt, that being a lawyer and also a law teacher, I'm mindful of the competing rights. For instance, the right to freedom.
Hello. Since it appears the host is having challenges, please, can any member of the forum
Albert, can you unmute yourself and continue, please?
Okay. Yes. Yeah. So I'm saying that I'm aware of the competing rights and powers. So as we all know, the judiciary has the power to make pronouncements on the state of the law, and that's nobody can take away from them. But the public also, has the right to make comments on judgments which are made by the courts of the Republic of Ghana. I think it's basic. It's very fundamental that, comments which seek to undermine or expose the court to hatred are not acceptable. Comments which, suggest that the court was doing something untoward, cannot really be acceptable. The challenge, however, is where you can draw the line. And honestly, that's where we all have a difficulty. At what point do you draw the line between a critique or an honest critique and comments which actually undermine, the authority of the Supreme Court? That line we haven't been able to draw very, very clearly. But certainly you are allowed to comment on the decisions that have been made by the Supreme Court. Now, the issue is that when the matter is sub judice or the matter is ongoing, you ought to be careful the extent of the comments which you make. And that's what we have been trying to do over here. We probably have to wait for the outcome of the case. Now, once the court has decided and the judgment is out, you and I have the liberty to take that document and subject it to the most harshest criticisms that we want to do. Except that when you are doing that, you must be careful that you do not disrespect or undermine the court in any way. So certainly there's a right to comment or the right to critique the judgments of the court, especially even those ones which have been given already. Now, I have written an extensive, commentary on some of the judgments which have been given already. And I believe that it's been all over the place and most people have read it. And I think that in that write-up, I was only expressing my views on what I thought the Supreme Court could have done in some of the circumstances. And so once you are able to navigate the narrow path, I'm very sure that you shouldn't find yourself in any challenge at all. Basically, that's what I want to say at this level. So yes, you have the right to comment, you have the right to critique decisions that be made by the courts, generally in Ghana. But when you do so, be careful not to make statements which undermine the court or expose the court to ridicule or some hatred, amongst the public. And for me, that's very, very important. And so we have to stay clear of that kind of situation. I think that goes to the last questioner on that. Now, there is also the issue of appointment of justice, and I don't intend to delve deep into this matter. But you see, for me, it is not about the appointment process generally. And I have to be very honest with you. I do not know how we can appoint judges without some form of executive involvement or legislative involvement, unless, of course, we want to make the office of judges an elective one, so that you campaign and you are voted for. But really, that is far-fetched, honestly. But I think that what we have right now is okay. For me, it depends on a personal commitment to do justice according to the law and to the oath of office that the judges have taken. For me, that's how I see it. To be a matter of personal commitment. But the current, situation we have, I don't know how we are going to navigate it. There will still be, the Judicial Council involvement when it comes to appointments like this. And for me, once you have been appointed, the good thing is that once you become a judge, you have security of tenure. You cannot be easily removed, unless there are some serious issues against you. And so that should give enough comfort for judges, to want to do the work the way they want to do it. But whichever way you look at it, I mean, people, as Uncle Pratt has said, people have personal biases. I do have my own personal biases. The justices have their personal biases, But that's the point I want to make is that the moment you become a judge, you have to try to be blind to these personal biases. And as I've said, or I've illustrated by the symbolic, depiction of justice, that justice must be blind to certain considerations. And I think that it must be a personal commitment. I don't see any other way to deal with that situation. It depends a lot on the judge who is deciding and whether or not he wants to be motivated by the law and his oath of appointment. And I think that's what most of the judges do or are expected to do in the circumstances. Yeah, so those are the two questions I immediately remember. Somebody also talked about if there is any evidence to suggest that the judges have been towing a certain pattern in terms of their decisions, if I recall carefully. And the question actually made a point that some time ago, I think my former lecturer, Professor Tuguba himself, had started a project like that. And I think he gave a bit of that presentation at a place. The presentation was not received, very well. And so in the absence of that, I cannot tell if there is any research showing that judges who are appointed by, a certain government have behaved or ruled a certain way. But as I've said in my presentation, at least I can give it to the period after 92, up to like 2000. I mean, as I said, a lot of cases went to the court within that period. And I cited some of them. And I'm saying that although most of those justices may have been appointed by the Rawlings regime, along the way, the judges decided that they wanted the good for this country, and it's immaterial who has brought the case before them. They will decide according to the law, even if heavens must fall. So for me, that's how I see it. But in terms of judicial assertiveness, I will give it to that period. I mean, after that period, I cannot point to any other period, exactly from my reckoning of and reading of the materials available. And as I said, before 92, there have been flashes of that, but there's no pattern. But at least post 92 up to like 2000, a little beyond that, and we can give it to that period and say that it didn't matter so much to the judges who appointed them. And I think that is where we should go back to again. Now, on the rulings that have been given so far, about 9 of them on interlocutory applications before the court. I mean, I think the verdict is out over there. Now, when judges give their decision, they are able to always provide a justification for that decision they have taken. Now, I have no doubt in my mind, and from my reading of the various rulings, I think the Supreme Court has provided to the best of its ability the justification for how it came to those conclusions. You can disagree with them, okay, on some of the issues, but trust me, they are based on some law. You may disagree with the law they applied, but they are based on some law. And that's the Supreme Court. What they say is the law. It becomes binding on all of us. And so we can only take it from that perspective. But again, maybe in the future, when the conditions are right, Professor Raymond Atugube's research can be pushed a bit further so that we can really come up with a clear pattern to see whether judges have voted because of who appointed them, or they have been assertive and voted irrespective of who has actually appointed them. I think that's what I want to say at this level for the questions that I can remember, maybe in the future.
Yes, there are 2 related questions. You may not have them, but perhaps you can share your ideas on them, and then we give room to Comrade Pratt to share his thoughts. One of the questions is, which is more important? Is it the law or justice? Because where we do not have justice, there cannot be peace. So is it the law that is more important, or is the justice that is delivered? Then the first question we had was, what steps can citizens take when judgment is not in the interest of the public or the nation at large? What steps can we take if judgment is not in the interest of the public or the nation? Which is more important, the law itself or the justice that is delivered based on law? Thank you.
Okay, thank you very much. Regarding which is more important, the justice or the law. Now, I think both are, for me, important, okay? Now, what we should realize is that when laws are made, the intendment is for it to result in the delivery of justice. As far as I'm concerned, any law which does not lead to justice is not law. It's not law. And so, I mean, we have to be sure that when we make laws or we apply those laws, there must be some fairness. And I mean, in preparing for this, I've come across some interesting articles, and I've read one article by one Professor Lucas, and I think the article is on JSTOR and Taylor and Francis. I mean, what Lucas has been trying to say is that, look, when judges apply the law, of course, there are different schools of thought. Some would apply the law, black letter law. Whether the outcome is favorable or not, it will be applied. That's another school of thought. But for me, the more favorable school of thought is that when you apply law, it must result in justice. And that when you apply the law, you must apply the law to persons. You must apply the same law to persons in similar situations. You cannot apply the law to somebody in this situation. And when a similar situation presents itself, you apply the law differently. And so those are some of the points. But law and justice are important. But for me, the end result of a law must be the delivery of justice. And as I've said before, it's really difficult to say you are pinning a definition to justice. But I said again, that when you see justice, you know it, you say it. And when you see injustice, you can tell. Basically, that's what it is. Now, if the judgment is not in accord with the expectation of the public, now the question is, what is the expectation of the public? Is it expectation of a section of the public, a political section of the public, or the public at large? Certainly, when a judgment is given, it will accord with the interests of some people in the public. and then it will, and for some people, you will not accord. But what I can say is that when a judgment is given and you are not happy, I mean, you accept it. If you have the opportunity to review or go for a review, you go for a review. And when the court say that they don't agree with you, as somebody has said, you have to accept it and move on. Because there's something that I want to say. In spite of every situation we find ourselves in, we cannot attempt to upset the current democratic order. I mean, we have a duty to protect the Constitution and all that. But in protecting the Constitution, we must ensure that we use legitimate means to do so. Because at the end of the day, if anything were to go wrong in this country, I mean, as Pratt has said, it's probably we will all suffer equally. So for me, when a judgment is given, you may not be happy. You may have the opportunity to exhaust other appellate remedies or review remedies. If it doesn't go your way also, you have to let go and move on. And that's extremely very important because any other option will jeopardize the security, the stability of our democracy. And that's how I want to look at it. Thank you.
Thank you very much. Comrade Pratt, any thoughts?
Yeah, first of all, I am a bit uneasy. I'm a bit uneasy when I hear the comment that protest is necessarily anti-democratic and that protest may lead to the undoing of our democratic experiment and so on. I feel very wheezy about that kind of suggestion. And I feel wheezy about that kind of suggestion because the 1992 Constitution gives us the unfettered right to protest. Unfettered. The right to protest is unfettered in the 1992 Constitution. Now, what is a democracy if people in the democracy cannot protest? Protest is an essential element in any democratic dispensation. So if you take away the right to protest, there's no democracy. And therefore, I believe that where people are dissatisfied with any institution, constitutional, state, public, whatever institution, the people have a right to protest. And the right to protest is not limited under our constitution and so on. And I don't think that every protest necessarily leads to a coup d'etat, or that any and every protest must necessarily lead to a situation where the so-called democratic order is upsetted. I do not accept that at all. So yes, it is true that the Supreme Court makes the final decision. It is true that there may be a chance for review of the Supreme Court decision. Even there, I think it's important for us to know that it's only a maybe. After the review, no court will sit on the matter. But the court of public opinion can sit anytime. We can hold conferences like this and talk our mind. We can hold conferences like this and disagree with the Supreme Court. Nothing prevents us from holding placards saying that I disagree with the Supreme Court. As it's all constitutional, it is all democratic, and nothing is wrong with that. Now, with regards to the appointment of judges and how judges behave, whether they do their master's bidding and so on, the only research that I'm aware of is the research which was conducted by Professor Atuguba of the University of Ghana. And it so happens that is one of the people I respect a lot. I mean, I have so much respect for him. And his integrity is obviously glaring and so on. There were attempts to stop him from fully disclosing the findings that he got in that research and so on, but we got glimpses of it. And it does appear that his research supports the claim that judges tend to vote along the lines of who appointed them and so on. It will be interesting if at a future date, that full research is made available for public discussion and scrutiny. It's an important element in our move forward and so on. But comrades, all my life, and I'm not a particularly young person, but all my life, the most scathing criticism of the Supreme Court that I've heard is one which came from His Excellency Nana Addo Dankwa Akufo-Addo. Not too long ago, Nana Addo Dankwa Akufo-Addo, our current president, His Excellency, launched a most scathing criticism of the Supreme Court. Indeed, after the Supreme Court made the decision that the fast-track court was unconstitutional, and the records are there. Now, if he, at the time, when he was Attorney General, could make that scathing criticism of the Supreme Court and so on, why can't we now? Why can't we now? Indeed, I want to follow his example. In fact, I want to be led by Nana Addo Dankwa Akufo-Addo in this matter. And I take Nana Addo Dankwa Akufo-Addo's conduct in this matter as a worthy example, worthy of emulation. Can I commit a crime by seeing the president as a role model? So I want to see the president as a role model. This is the president who launched the most scathing attack on the decision of the Supreme Court. And in fact, in that video, which I've seen, he even goes to the extent of analyzing the influence of the appointing authority on the conduct of judges of the Supreme Court. I'm not the one saying it. This is Excellency Nana Addo Dankwa Akufo-Addo who makes that point. We are asked whether or not the law is perfect and so on. No law can be perfect. In fact, no society can be perfect. And if no society can be perfect, no law can become perfect. The point is that we are constantly trying to breach our boundaries, constantly trying to breach our boundaries. We are constantly trying to breach the boundaries of free expression. We are constantly trying to breach the boundaries of decency and so on, of all the concepts that we know about. And this attempt to breach boundaries is an attempt to improve the existing order. So we do not have a perfect situation, and I don't see how we can be in a perfect situation considering the dialectic principle that everything is in motion. You understand? Considering the principle that we are always moving from lower quality to higher quality and so on. And this is physics, this is science, you understand? So for as long as we continue to move from lower quality to higher quality and so on, no situation of the law can be perfect, but we ought to strive towards perfection. And in striving towards perfection, I would suggest very strongly that at least we know that the judges are human beings. We know that the judges have their own biases, just like all of us do have our biases and so on. But at least let's set a cap on the number of judges who can be appointed to the Supreme Court. Because it has been demonstrated in this country that sometimes when the authorities are not happy with the judgments of the courts, they can introduce additional judges in order to change the decisions of the court. And it happened in the Chachuchikata case, where 2 new judges were appointed onto the Supreme Court, and those 2 new judges made a difference between whether or not the fast-track courts were constitutional or they were unconstitutional. Now, it's important for us to understand that one of those 2 judges who was appointed to the Supreme Court, Justice Afre, had actually been sitting at the fast-track High Court. And therefore, he was not expected to condemn himself. So therefore, his appointment to the Supreme Court could only have been intended to reverse a decision of the Supreme Court. Now, if we had a cap on the number of judges who could serve on the Supreme Court, it may help to deal with these excesses, you understand? Now, who am I to pass judgment on the future conduct of judges? First of all, how much law do I know and so on? You understand? No, very little law. But given the current situation in which we are, if one president in one term appoints 11 judges of the Supreme Court, we ought to be worried. Given the interpretation that His Excellency Nana Addo Dankwa Akufo-Addo himself has given to the effect of appointment of judges and so on. So we ought to have a mechanism which ensures that no one party, no one president is able to pack the courts. And this is something that we can achieve. Now there's a question about freedom and justice and how it can be achieved. And does the law always and necessarily achieve the ends of justice? And I fully agree with Albert. If the laws cannot achieve the ends of justice, then the laws are useless. The laws must necessarily lead to the achievement of the ends of justice. Thank you, comrades.
Thank you very much, Comrade Pratt. We have food for thought. I see only one hand up.
Oh, no.
And okay, Abdul Malik, I promise that you come in next. So can you kindly pose your question?
Thank you very much, distinguished chairman, and a very good evening to lawyer Albert Kwesi and our uncle, Comrade Pratt. I actually asked a question yesterday, and it appears, unfortunately, our legal brain went off for technical reasons. And today, listening to lawyer Albert Kwesi makes it more confusing, especially when he attempted responding to a question. And he noted that all the rulings that has been given so far as the election petition is concerned, is based on some law. Vice Chair, if you remember, my question yesterday was, especially, and I'm going to marry it with lawyer Albert's submission today, where he noted as part of his submission that fairness in giving their ruling, it must be fair, or they must be fair in the application of their rules. And now, I asked a question yesterday that in the 2012-2013 election petition, we monitored proceedings and were told that interlocutories have been granted based on CI 47. And in this particular petition, we have been told by the justices that they are unable to apply CI 47 because of CI 99. Of course, arguments have been put across that in CI 99, it doesn't talk about interlocutories. Now, I would like to know from lawyer Albert that which precedent are we to take? Is it the 2012-2013 election petition that granted interlocutories, or the 2020-2021 that refused to grant that on the basis of CI 99, which is even contestable? And also, do I take it to mean that this particular ruling on interlocutories has set aside CI 47 and the 2012-2013 ruling on interlocutors? I want to know from counsel, and respectfully, I would like an in-depth explanation to that effect. The second question is, I have also read the ruling on interlocutors, not the review, and the justices mentioned, haven't agreed that the petitioners indicated the interlocutors was to narrow issues in the case. And beyond that, they thought it was irrelevant. And he has made clear in his ruling that, in his submission, that they would provide a clear reason. If you read the ruling, there's not any clear reason to that effect. They only say it's irrelevant in the opinion of the court. Those questions are irrelevant. So I would like to know from counsel, is it enough for justices to just say something is irrelevant, or they must provide cogent reasons to that effect? Thank you very much, Vice Chair. I'm grateful.
Thank you. May we have a question from Professor Mauli Salah, and then we'll get back to our presenters.
Thank you very much. Wonderful presentations. This is a short comment and a question, Dr. Koshiga. So you are telling us that Supreme Court rules, and everybody knows that they are the way they are, therefore the status quo, the presidency. So after that, we know there's injustice, and we just go home and say we want democracy to continue. They are trying to make democracy not to continue. So if we capitulate to them, what about the people who were killed, which we've never had in any election? And what about all the wrongdoings? Or what about all the other constituencies that they've not ruled on? We are in kangaroo court here. So what do we do? Because if we let this injustice continues, then that is rather threatening our democracy. Thank you.
Thank you, Professor Salah. We have seen another hand up. Beamfest Limited. Hello.
Hello, Prof.
Go ahead, sir.
Yes, my name is Adekoka. I want to ask just two questions. One, does the Supreme Court take into consideration public opinion? And two, why are they not allowing oral presentations before the verdict? These are the two questions I want to ask.
Thank you very much. Johnny,
Hello,
I can see
Prof.
your hand, Johnny.
Yes, Prof. Good afternoon, and thank you so much for the opportunity. And thank you to our presenters, Comrade Pratt and Comrade Kwesi, for your great delivery. But my concern has basically been on the consequences of the verdict or public confidence in the judiciary and also accountability of public officials and public institutions. Now, if the verdict just does not take into consideration the fact that the EC, okay, was supposed to have told us really the reasons for for the first time, having several election results and not knowing really which ones we are working with. For the first time, we have an EC, okay, who came to deliver a result, and the following day, a new result came, and as we speak now, we have no reasons, we have no explanations to that. Now, what remedies do I have as a public-minded person, okay, to demand accountability from such a public official? That's my question.
I saw Francis Ajay's hand. If he's still interested in asking a question. Otherwise, this should be the last question for the day.
Prof, thank you very much. Mine was not a question per se, but rather a comment. If I'm allowed, I'll make it.
Go ahead, please.
Thank you very much. Appreciation to our colleagues, Albert and Comrade Pratt. I want to believe that Albert situated his lecture within the practical context of judicial review as the main instrument through which the judiciary provides an anchor for democracy. That is why he cited several authorities. And in support of what he was saying, there's another theoretical standpoint which has to do with the separation of powers, where the classical work of Baron Montesquieu provides for separation of powers, whereby the judiciary seems to balance all the other activities that happen within a democratic institution. I understand the frustration from some of our colleagues, like Professor Salah, in respect of the answer given by our colleague Albert. Yes, it's true. It can be very frustrating sometimes when the desires or the expectations of the public or the opinions may not be what influence the decision of judges. But we must also accept that democracy has its own levers or its own actually organs that run it. We cannot sidestep those same organs, no matter how faulty or how fallible they may be. As much as possible, we need to accept that this is the institutions that actually constitute what democracy is and work with them. One speaker earlier made mention of something which I think touches very much on the nerve of these frustrations that the lives of Professor Salah have expressed. Yes, our constitution is one of the good ones, but we had opportunity to make certain corrections. We started it by constitutional review or constitutional amendment. The commission started this work under the same socialist government. Unfortunately, we did not see the light of day. We could have prevented some of the things that we are seeing today if we really held the bull by the horns and then actually placed certain limitations on appointments to Supreme Court, for instance, which was actually one of the recommendations by that commission. But I think we didn't really push them through well. But today, this is what we have. Well, it may be frustrating, but we just can't do otherwise against the various institutions that actually hold democracy. Thank you.
Thank you very much. Well, since we've all been patient and carried the day to this level, I see two more hands.
Honorable,
I thought that was the last hand, but may we please have Francis and then we take Audu as the last questioner. Thank you.
No, okay, Mr. Moderator, I've also been trying to raise my hand, so after the two, allow me, please.
Okay, so you'll be the last one. Let's take Francis, we take Audu, and then Michael. Thank you. Michael, kindly mute your mic.
Thank you.
Francis Johnson here, and with respect to the Supreme Court, I want to know if there's anything that can be said for regional balance and tribal balance on the Supreme Court. And then, will lifetime guarantee in any way reduce the political influence on the Supreme Court?
Thank you. Colleagues, I would like to plead with you that
lifetime tenure guarantee.
Francis, are you done?
Yeah, I was saying lifetime tenure guarantee. Will it in any way mitigate political influence on the court?
Okay, thank you. I was going to plead with Audu and Michael that we have a lady. We haven't heard the voice of a lady on this in this forum. So I saw Barbara. Barbara, if you are still interested in asking, may you kindly ask? Barbara. Okay, then let's have Francis.
I already asked my question.
Oh, okay, then I will do.
Yeah, thank you very much, moderator. My question is, when justice is denied and when people add their views, then they were slapped with contempt, what avenues are open for them to seek redress? Don't you think that this is a threat on our democracy? Thank you.
Thank you very much. Lawyer Kwesi, would you kindly help us address some of these questions?
Okay, thank you. Thank you for this opportunity again. I think that I made a comment in response to a question. I think that a few people have disagreed with me because I've made a point that if the final judgment of the court were to be given and it did not accord with the expectation of society, the persons involved may have the opportunity for a review. I mean, or once you go for a review and you are still not successful, you must actually just reorganize yourself for the future. And I think that most people have been expecting the point to be made that when the court gives a decision which is not favorable, people should be able to do something else. I cannot sit here and make a call that would not be in accord with the Constitution of the Republic of Ghana. Now, what I'm saying and what I'm trying to say, is that when the court, I mean, before the judicial process, when the court has given a decision, if at this level, at the Supreme Court level, your opportunity is to go for a review. Now, beyond that, there's nothing else, as Uncle Pratt has said, you can do. Now, the rest is for the court of public opinion and a matter of political strategy going forward. But in terms of when it comes to the application of the law, there's no other court beyond the Supreme Court in terms of our jurisdiction, which you can go to. So if you exhaust the review jurisdiction and it still doesn't go in your favor, my humble submission on this matter is that you have to move on. The rest will be a matter of political strategy. And that is the point I want to make. And I want to emphasize that point. And I see that Professor Salah, has actually, said doesn't agree with me. But I think from the legal perspective, that's the right thing to do. Take a review opportunity. If it doesn't work, you have to consider other political strategies. And that's not what I can comment on. I leave that for political parties to decide the strategy they are going to take, whether they win or they lose the decision, they lose the judgment, which is about to be delivered. So that's my response to that question. Now, somebody also asked the question about regional balance and whether life tenure could guarantee some form of judicial assertiveness. Well, if you look at the appointment to the Supreme Court, if you look at Article 128, Clause 4 of the Constitution, now it tells you, the qualifications which a person may need in order to go to the Supreme Court. And if you permit me, let me just read it out for you to hear. Now it says that a person shall not be qualified for appointment as a justice of the Supreme Court unless he is of high moral character and proven integrity and is not less than 15 years standing as a lawyer. Those are the qualifications. So for instance, there's no requirement that some number of justices must come from a particular region or not. I am not aware of such a requirement. What I know of is what is in Article 1284 of the Constitution, which says that you must be somebody of a high moral character, proven integrity, and not less than 15 years standing as a lawyer. And that's how I want to respond to your question. In terms of lifetime tenure guaranteeing some form of judicial independence, that's not a bad idea actually. But I think already, even in countries where, for instance, in the US where judges enjoy life tenure, it doesn't mean that they cannot be removed on certain grounds. Okay, so in this country, our judges enjoy something close to that. That kind of security is there. Okay, but it doesn't also mean that on certain grounds they cannot be removed through a certain process. So whether you have a lifetime tenure or not, there could still be grounds on which a justice could be removed from the Supreme Court. There are still grounds on which those things can be done. So really, you cannot have a perfect situation when it comes to things like this. Okay, so I hope I have addressed that question. Now, my good friend Dr. Ajay made a comment on the separation of powers, and I endorse that. And he also made the point that given the current situation we have at our hands, or the current system we have, we have to accept the decisions of the courts. And let me emphasize again that the rest will be a matter for political strategy and what the politicians say and how they respond to the judgments. That one is not within my power to say as somebody who has studied law and applies the law or practices the law in some way or the other. That's not mine to say. So one, yes, the political parties will decide exactly what they should do once judgment has been given. Now, somebody asked a question about, yes, I don't know if it's, I think I didn't get that question. I was writing so fast, but I think it had to do with how the Supreme Court conducts its proceedings somehow. Now, and whatever the question is, I think the response I wrote down addresses that question. So whoever has a question, this should address your question. Let me tell you. Now, every court in this republic, okay, is guided by rules. We call them rules of court. So the district court has its own rules. The High Court has its own rules called CI 47. Now, the Court of Appeal has its own rules which guide its procedure. The Supreme Court has its own rules also. Now, when it comes to how to take evidence and control proceedings in the court, each of those courts have control over what they do in their courts. Unless what has happened there, results in some miscarriage of justice, it's difficult to question how the judge does the things that, he does in his court. So there are grounds to ask for judicial review when it comes to how judges conduct themselves, and that's there. But I'm trying to say that when it comes to the taking of evidence and some procedural decisions, the courts have control, and they exercise that control within the context of the rules that guide the court. Now, those rules, I can say, are subsidiary legislation, like constitutional instruments. They are not laws made by an act of parliament. Although somehow they go through parliament for a period of 21 sitting days, they are subsidiary legislation. Ordinarily, parliament should be making all those laws, but those powers have been delegated largely. So, what my problem has been is the way the rules of court have been used as, the gospel, such that the courts are unwilling in certain circumstances to even, to get out or to apply the laws in a way that results in justice. That's the problem I have with the application of the rules. And trust me, I've made this point in a write-up, which is always in the public, that there are some decisions the court took. For me, they were too based on procedure when we should have been looking at the substance of the matter. And I've made that point clear. And I have no regrets. I'm making that point again, that the court could have, on its own, decided to apply the rules a certain way. And I've also made the point that the rules of court are not mistresses. They are not masters. They are servants. They are only supposed to help us to achieve the ends of justice. So when we are applying the rules of court, which I say each of the courts have, you must apply it in such a way that it does not lead to a miscarriage of justice. And that's how I want to look at that question. I hope that it addresses that. Now, somebody also raised the issue of CI 47 regarding the High Court rules and its application to the proceedings in the Supreme Court regarding the petition, and then CI 99. I have to tell you, CI 99 is a very strict, procedural rule which was made, okay, as an amendment to the Supreme Court rules. Now, although it does appear that the rules are intended to achieve a speedy, delivery of justice in the case of the election petition, I think that these rules could have been applied in some other way, which will bring substantial justice for me in a lot of ways. Now, the application, in fact, and I have to say that the Supreme Court all this while, the opportunity for interrogatories and discoveries and all that, these are things which are contained in the High Court rule, CI 47. And most of these rules have been brought up in the Supreme Court in this election petition. Whether they have been upheld or not is another matter altogether, and they haven't been. For instance, the issue of interrogatories is a key part of the High Court civil procedure rules. Now, in 2012, you and I know that similar orders were granted, but this time around, the orders have not been granted. So what is the position when it comes to precedent on interrogatories, for instance? Somebody asked that question. And I'm saying that the Supreme Court the Supreme Court can follow its own previous decisions, but it is not bound by its previous decisions. So the Supreme Court can depart. Now, between you and I, as we sit here now, those rulings on interrogatories in this election become the new position of the law regarding interrogatories. And as I've said, many people have disagreed with how the Supreme Court has ruled on some of these matters. But whether you disagree or not, that's the position of the law, that when it comes to petitions, the interrogatories must meet a certain standard. And honestly, it has always been the case. But eventually, it becomes a question of fact, whether the questions being asked in the interrogatories are actually relevant to the determination of the issues. And if you ask me honestly, I think that the questions which were being sought by the petitioner for me were relevant. And so I disagree with the Supreme Court when the court takes the view that the interrogatories were not relevant. That's one I disagree with the Supreme Court. But I mean, what does it count for? They have ruled already on that matter. And so basically, that is what I like to say on the application of CI 47 and then CI 99. For me, CI 99 is a strict rule, and the court is applying it strictly in order to decide this case timeously. And as I've said, we can always disagree. We can always disagree with the court. But even if you are not happy, you have to move on. The rest is a matter of a political strategy. That's what I want to say. That's what I want to say on that. Somebody asked a question about contempt. That when the judgments are given and then you try to talk, your contempt is hung around your neck. The law is that, look, all superior courts have the power to punish for contempt. How much more the Supreme Court? You see, so you can disagree with the Supreme Court on how they have used the contempt powers or how they seek to use it. And that's the right we have. But the Supreme Court has that power to exercise. And in some cases, they have exercised it. In 2012, we saw that being exercised in a number of situations. Okay, I mean, you may be concerned about where the boundary is, the boundary between freedom of speech and expression and the authority of the courts to punish for contempt. And I'm saying that that boundary has to be defined clearly. That's why Uncle Pratt has said that maybe going forward, we should be able to actually delimit the scope or the elements of contempt. But then again, the downside to that proposal is that too many conducts can constitute contempt of court. You may not reasonably foresee all those conducts. So if you circumscribe the grounds for contempt, now in the future, if some conduct which undermines the court's authority surfaces, do you allow it to pass because it is not written clearly in the law, or you have to continue to amend the law? And these are questions which are not easy to answer. But I mean, I have my own, disagreements of how the powers of contempt, have been used. Today, in my media law class, I mean, a lot of my students have made comments on the letter written by the judicial service concerning, the comments which have been put on news websites and all that. I think even most of my students who are studying media law at this level feel that, I mean, given the freedoms given to the media and the freedom of speech and expression, they are concerned that these kinds of acts are seeking to cow people into submission and are thinking that we are returning to the days of the culture of silence. For me, that's the view I get from even my students of the class. So really, these are difficult matters to address. But again, the entire public is watching. Those from whom justice emanates are watching what is going on. And I believe people have formed their own views on this matter. So basically, that's what I like to say on the consensus raised so far. Yeah, basically, yeah.
Thank you,
Yes,
Albert.
yes.
Thank you, Albert. May I please that we hear from Michael, who will be our last questioner. I saw Pearl, but Pearl has dropped her hand. So Michael, what do you have for us?
Thank you. Just to bring something that seems to be sounding from Dr. Kwesi, bring it to limelight. That justice must be seen as being done. Dr. Kwesi, is it grounded in law and legal system and justice delivery system? If it is, then I've been wondering whether the Supreme Court had it in mind when the EC chair was being shielded from being questioned. How can an election petition not have the EC chair speak? Did they have in mind, do you think they had in mind that part, that law or justice must be seen? And that is where, to be seen by who? By all of us. And if we see that it wasn't the case, then that's why protests and so on come in, as Uncle Pratt said. Thank you.
Well, if I may just be allowed to make a few comments.
Please go ahead.
Because I'm supposed to be on air this time. So.
All right, sure.
Here is the point. No institution or authority in any country has powers that supersedes the powers of the people. The people are the ultimate arbiters. They are the ultimate decision makers. As a matter of fact, the people of Ghana, through the expression of their sovereign will, can even decide that they don't want a Supreme Court. The people of Ghana can actually write a constitution or vote for a constitution which says that we don't want a Supreme Court. You understand? So to that extent, we need to recognize that the people are the final arbiters. Of course, if you're taking the legal and judicial part to arbitration and so on, your final stage is the Supreme Court. But beyond that, the political part. And the political part is legitimate, it is proper, it is democratic. We can decide that in the light of the conduct of the judiciary, we want another system which would serve as a system of arbitration and the resolution of conflicts in our country, and not what we have today as the Court of Appeal, as the High Court, and as the Supreme Court, and that would be perfectly all right. So don't let us forget that the final arbiters are the people of this country.
Thank you very much. And we have heard from Comrade Kwesi Pratt. He is expected to be on air at this time, but he has taken pains to share his wisdom, knowledge, and experience with us. So if he disappears before us, on behalf of the Chair of Progressive Intellectuals, Professor Stephen Kendi, all members of the Progressive Intellectuals, I'd like to thank him sincerely for accepting to join us. This is not the end of our public forum. This is just the beginning of a series, and we hope to be seeing him one more time. So we are not yet ended. We've had a number of questions, and I see Michael. Do you want to ask another question? But I think you've asked questions already.
I've asked my question.
Yeah, Pearl wanted to ask a question, but she's now rejoining. So all I have to say is that we've had a very fruitful deliberation. In summary, we heard that the law and justice are equally important. However, any law that does not lead to justice is no law at all. And that one sank very well with us. The application of the law must result in justice. So the question is, what do we do when we don't see that justice which we expect? Lawyer Koshiga was advising that should we not see the justice we expect, we must use all legitimate means to protect the constitution of our nation, the constitution of our country. Use all legitimate means. Then Comrade Pratt came in to say that yes, once we are to use all legitimate means to protect our constitution, protest is not undemocratic, because the 1992 Constitution gives us Ghanaians the unfettered right to protest, and it is part of the legitimate means by which we can seek justice in this country. So taking the right to protest away from Ghanaians would curb our democracy. Beyond that, in protestation, the court of public opinion is a legitimate means of seeking redress and justice in our country. And in using such legitimate means, we must be bold to critique even the Supreme Court, as we have been shown by the current president of the country, Nana Addo Dankwa Akufo-Addo, who boldly critiqued the Supreme Court when he felt that he had to express his opinion. Comrade Pratt also advised that in striving for perfection, we must be aware that it is difficult for us humans to achieve perfection. However, if we want perfection, near perfection in justice delivery, then we must ensure that there's a cap on the number of judges appointed to the Supreme Court and other courts of our nation. A very important point. Finally, he also advised and also encouraged us to understand that the people, which means the people of Ghana, are the ultimate or final arbiters. They are the final decision makers in this land. And the people can decide whether or not they want the courts to administer justice or not. So the people are the final arbiters, and we must not take that right guaranteed by the Constitution of our nation away from them. Colleagues, we've been on this for over 2 hours, and yesterday I did remind that any intellectual exercise that goes beyond 2 hours disturbs the brain. It's not biologically healthy for us. So I would wish to bring this session of the series of fora that the progressive intellectuals will be organizing to a close. This is not the end at all. We will be back after the verdict of the Supreme Court, and we have other important issues affecting us in this country. The essence is to ensure that there's due diligence and to ensure as well that whatever we do, whether it's justice delivery, economic development, social and cultural transformation, must translate an improvement in the conditions of lives of Ghanaians, give us satisfaction so we can feel the best of ourselves and make our world a better place to live. On that note, I'd like to thank you all for your patience. We've all comported ourselves very well, and I believe that the next time we invite you to join us in such discussion, many of you will turn up. We have made room for 500 people, and so you will soon hear back from the progressive intellectuals. Have a very good evening, and may God bless you.
Hello, Prof.
Yes,
Prof,
please.
Please, I beg you, let me issue a caveat. I am still a doctoral student, so I'm not a PhD yet. So I think people are calling me doctor. I'm not a doctor of books yet. Okay, thank you.
Thank you very much. Thank you very much. That is a mark of an intellectual. There are some who always want to refer to themselves as doctor, professors, or reverend doctors, so and so, and yet they are not yet. So thank you very much, Mr. Albert Kwesi. Thank you. Yes, sir.
How can we, Dr. Baita here, how can we get access to when you have these seminars? I find it fascinating. I'd very much like to listen to any future one. Is there a site we can reach for this?
Yes, we'll post that on the platforms. Everything that has transpired has been recorded. And then we have a professional who is also recording. It will be on YouTube, and then we can have the link to that by tomorrow morning. We should have it in order for the general public to have access to it, and you will certainly have access to it.
Abokadrika Mijabanovio. Excellent.
Hello. Thank you very much.
Thank you.
I like that aspect.
Abokadrika.
Yo.
Thank you. Thank you.
Thank you very much. And may God bless our nation and the generations after us. Have a good evening.
All right. Thank you.
Thank you.
Thank you. Thank you. Great presentation.
Thank you so much.